Good afternoon, ladies and gentlemen. Thank you for joining me today. My name is Alex. I'm a partner at an entertainment law firm of Chase lawyers, named by our senior partners, Mr. Barry Chase. We've been around for about 30 years, and Mr. Chase started the practice back in 1996 after acting as a VP for public broadcasting station and doing a lot of good work in putting documentaries and movie projects in front of everybody's eyeballs until he came over to Miami, where we're currently at, and started a firm which has now been in existence for 3 decades, and we've had a pleasure of working with a number of movie investors and production companies, and starting out movie makers, DIY producers and directors. So we've kind of had a chance to see the full scope and spectrum of different executions when it comes to putting together a movie project. And today we're going to talk exactly about that. What is that legal checklist that a producer should have in place before pre-production starts? So most production legal problems do not necessarily originate during distribution or release. They originate during development and pre-production. Unfortunately, once production is underway, legal mistakes become exponentially more expensive to fix. So the purpose of this presentation is to walk everybody through the practical legal checklist that the producer should have in place before cameras start rolling. And I'm happy to be here with you, together with the kind folks at Filmustage, and happy to contribute some value to this community. Why legal must start before creative spend? One of the biggest mistakes independent productions make is treating legal as an afterthought. A lot of productions begin spending money on casting and locations and crew and equipment, marketing, understandably so. And all of that usually comes before the legal structure is secure. That creates a lot of major risk. Some of the most common failures, or I guess fail points, would include unclear IP ownership and people who have contributed nothing to the project claiming that they have come up with every single character and plot twist. There being no chain of title, investor commitments being undocumented, or appearance releases, personality releases, talent agreements not being executed. These are some of the most general, commonly seen problems that we help our clients face. And the problem is that these issues usually do not appear immediately. They appear later when the production seeks financing or insurance or distribution or errors in emission coverage or investor due diligence. That is mostly when it comes up. At that point, the legal gaps become extremely expensive delays, potentially prohibiting and preventing you from raising funds. One of my favorite lines is, it's right here: fixing it in post is not a viable legal strategy. Legally speaking, pre-production is where risk prevention should happen. So keep that in mind as we're kind of moving forward. Just make sure to tackle a lot of the problems, and worst case scenarios can be avoided if things are properly structured early. So speaking of structure, what is the proper legal entity and business structure for a producer? Now, before production activity begins, the proper legal structure should already exist. One of the first questions is, what entity structure makes the most sense? And that could usually involve an LLC or a corporation or specific special purpose vehicle, SPV, or an international co-production structure, if that's of benefit due to taxation reasons or the existing rights holder interests Many productions use single-purpose entities to isolate risk to a specific project, meaning for each specific movie, a separate LLC is put together, and then whoever is the investor or owners of the project, they own through their independent entities in that project LLC, which becomes extremely important to protecting investor liability, in preventing lawsuits, and ensuring separation of any creditor claims or debt, as well as contractual exposure. And obviously, operational governance should not be undervalued here, underappreciated. It's extremely important to identify who owns the IP, who can sign contracts, who has authority, who controls banking, who approves expenditures, what are the functionalities of every single member of the team. Are they, is there something for them to then compare their production to in order to assess whether they are performing properly or not, or is everybody just operating under the assumption I'll wear as many hats as possible and I'll do everything, and then everybody's burned out and half of the things are not done. You need to ensure that you have that understanding and clarity in advance. Additionally, productions should establish dedicated business bank accounts, specific escrow procedures, specific approval systems, and accounting and payroll softwares alongside it as well. Because once investor money enters the picture, it becomes pretty dangerous to continue being informal. Let me tell you that, because now it's the investor's money that's on the line. When it comes to chain of title and IP ownership, this is one of the most important legal concepts. Chain of title refers to ownership and your ability to show how that ownership originated and how that was then passed over to you as the producer, the production company, from every single respective editor and cameraman and actor and anybody else participating in the creation of the product that you then intend to put on the screen. If you don't have every single slice of that proverbial pie chart covered when it comes to ownership and every single person contributing to the production being properly papered, including scripts, treatments, and artwork and logos used in the background shot of whatever it is that you're trying to put on the screen, any pitch decks or any music used or any ancillary rights like name, image, and likeness rights. If a production is further based on a book or story or a life story rights option, it's usually the type of contract that is executed with somebody famous in order to tell, or I guess somebody with any notoriety to tell their life story in the format of an audiovisual production. It can also come in the form of a remake, a sequel, a prequel, and in all those instances, the rights must be secured properly before any development progresses. Now, another new issue is AI-generated content. Producers need to think carefully about ownership, as AI is not able to be an owner or a copyright author within the meaning of US law. And so you want to ensure that whatever use you have of AI in your production, it's as limited as possible and is properly commercially licensed if there's an opportunity to do so, meaning the same way how we used to look at royalty-free music and libraries and having that option be available to you, being an important part of putting together a production and not violating third-party rights. In the same way, we want to ensure that we do not necessarily expose ourselves to or limit our ability to monetize in a potential acquisition scenario if an overwhelming portion of your production is AI generated and now cannot be copyrighted and now has limited ability for it to be sold to somebody since you don't own it. So without a clean chain of title, whether AI is involved or not, the distributors are going to hesitate, the insurers are going to hesitate, the investors going to be wary, and the buyers are going to stop answering phones. make sure to own the production that you're putting together. Now we can move to contracts, right? Outside of proper legal structures and proper intellectual property ownership, contracts is usually that missing piece that allows you to fill any gaps that are not provided for in the legislation. How is that so? For instance, there are different ways how you can protect your IP, but not all creative production is protectable. Like ideas are not content that you can protect just due to how unexpressed they are. In order for something to be protected by copyright, it needs to be expressed in a tangible medium for somebody to perceive, meaning I can't think of something and then go to somebody and say, well, I've actually thought, and somebody does a song, and then I go and tell them, well, actually I've thought about it before you sang it, so I own it. It doesn't work like that. You need to express it, right? So with that, there's always been a gap that is generally and industrially has been filled out by contracts in the form of your ability to limit people in their ability to disclose information about your project. What you cannot obtain through IP registration, you can have a NDA for, you can have a non-compete for, you can have a non-circumvention for, and you can have a trade secret policy in your company protecting specific procedures or specific formulas, specific business processes that allow you to get that economic value, however it is that you've decided to optimize your production. Now with that, the production is only as strong as its documentation. Many independent productions operate on verbal understandings or formal handshakes, and definitely incomplete paperwork, which becomes a major issue later. Co-production documents typically need to include founder documentation, right? That legal entity, operating agreements, shareholder agreements, bylaws, producer agreements, writer agreements, director agreements, investor documents, as well as any third-party sponsorship, commercialization, marketing agreements, native advertising agreements. Another critical point of contention here is financial structure. Who recoups first? How does the waterfall, we'll talk about it in a little bit, look? How is back-end participation calculated? Who controls accounts? All of these issues should be documented clearly before financing closes. If you have things properly set out in paperwork, you'll have clarity for investors, distributors, business partners, and clarity worth a lot of zeros, let me tell you that. So what are some of those key agreements that we need to be looking at in putting together a production, or at least that we need to be conscious of depending on what types of service providers we work with? Talent agreements generally include more than just simply hiring actors. They address compensation, exclusivity, image rights, merchandising, sequel rights, publicity rights, which is image likeness rights, as well as approvals and kind of further usage and equity consideration as well. Union compliance also comes in quite handy if you're involved with any SAG-AFTRA members. And if the rules apply, then your production must comply with requirements for wage and reporting, pension, health, as well as standards of your production. Especially when minors are involved, this is where state laws impose specific rules dedicated to trust accounts, a specific portion of the earnings by child actors being retained for outside of the parents' control in a locked trust account, the Coogan law and the different digital creator, video blogger laws that are now in effect in a number of different states. But yeah, when minors involved, additional protections apply when it comes to Coogan law and labor laws and parental consents, as well as specific limitations that each state imposes on productions as far as work hours and educational opportunities. But at the end of the day, new categories are emerging. We're not just bound by the Coogan law, that I think appeared first in 1939. Now we also see in a lot of new categories of influencers and athlete deals and celebrity cameos and creator participation structures, all of which need to have a proper agreement supporting them, creating different legal and business consideration, as I'm sure you understand. And moral clause is also definitely of value for consideration as far as ensuring that no events in the personal life of your castmates and talent don't affect the potential commercialization of your project. Let's talk about crew and employment and independent contractor risks. You want to ensure that you are not exposing your production to risk by misclassifying your workers. Many productions improperly classify workers as ICs or independent contractors when they legally should be employees. That creates payroll tax risk, labor violations, overtime liability, and complications with unions. If you are planning on onboard a crew, you should have a proper deal memo or a term sheet. You have payroll software and provision of specific payroll timing in your contract with the crew member, specific work for hire provisions for intellectual property created by the contractor or employee, confidentiality and compliance policies. Also similarly could be an addendum or an exhibit to your main contract with your crew member. You need to also ensure that you, as a production who's hiring people to create a movie, you need to address workspace safety, preventing harassment, as well as complying with any union obligations or immigration rules. Production is a business operation at the end of the day, and legally it needs to function like one. So take that into consideration. One of my favorite topics, music and soundtrack clearances. So I would say about 50% of our practice, in addition to film and TV, is dedicated to helping music artists and record labels in their negotiation and rights protection and rights registration and clearances. And this is where, two of our worlds collide. Music clearance is one of the most underestimated legal risks in audiovisual and movie production, because using music without proper clearance can stop distribution entirely. These are usually a number of rights that are involved in audiovisual production. There's usually two types of copyrights when it comes to music, any music work, and that would be a sound recording and a composition copyright. And each single one of those needs to be licensed in order for your production to have the full scope of permissions, meaning, and the ownership for each single one of those can be different. For major music artists, a record label is going to have a portion of, or the whole ownership of the masters, while the publisher, or in the co-publishing scenario or full publishing scenario, is going to have partial or full ownership of the associated composition of publishing. And obviously the more leverage the artist has, the more rights they're able to retain, and the more it turns into a licensing structure as opposed to an ownership one. But to kind of sum it up in the context of an audiovisual movie production, there's usually a number of rights involved. Sync rights for the composition, master use rights for the sound recording, as well as publishing rights associated once again with the composition. And those composer agreements matter significantly. You need to ensure whether the score, the underlying work, is work for hire, meaning belonging to your audiovisual production, belonging to your LLC based on a specific express agreement for said work for hire provision. Does the composer retain any publishing? So can they continue recouping every time the work is played and there's associated performance or mechanical distributions associated with that publishing associated with his composition? Who owns the soundtrack exploitation rights? Is it your audiovisual production company? Is that a third-party distributor? Is there somebody is there a sync library? Sample clearances create a lot of issues at the end of the day. We see a lot of clients doing them post factum, or trying to do them at the last possible second. But the general rule is you never want to be delayed by somebody not responding to your emails because you're trying to get the beat licensed and they're not very good with their comms. Every single one of those kind of scenarios just brings us back to having things done properly from the beginning. And music law is a major component of any legal strategy for an audiovisual movie production. Locations and permits play a pretty significant role, understandably so, and we see people underestimate those and not have proper location releases. However, it's more than just about finding a place to film. Production needs a location agreement or property release. They need municipal permits, potentially need drone permissions, as well as venue approvals, depending on how public your filming is and how much how significant it is, how big the production is, and whether that goes beyond anybody's individual private property where a property release or location agreement is going to be sufficient, and how much do you go into the public property requiring those municipal and further permits. Another significant issue there is brand visibility. If your trademark, somebody's trademark, is appearing in the background, that can clear the clearance concern. So that's why you see, car logos blurred or backpacks, logos in the backpacks blurred in some TV shows or movies, is because they couldn't clear a trademark, meaning a trademark owner asked for more money than they actually had the budget for. Speaking of budgets, tax incentive play another major role. Many production structures shoot strategically so they can qualify for tax credits provided by different states, payroll rebates, as well as international treaty benefits when those are applicable and when there's obviously international filming. But at the end of the day, productions need to comply carefully with any and all local labor requirements, reporting obligations, and residency rules as well. Otherwise, they risk losing the incentive entirely. So make sure to be careful about that. Now that we've reached, the latter portions of our presentation, we're gonna talk about a lot of the most important steps in establishing your production is properly protected, and insurance is going to be one of those core pillars of protecting your production. Different productions require different coverage structures, which generally may include insurance for general liability, for workers' compensation, equipment insurance, cast insurance, cyber attacks coverage, and of course errors and omissions insurance. And the highest kind of risk productions may also include some stunt riders or weather coverage or animal use coverage if we're filming a safari movie. And errors and omissions insurance is particularly important because distributors often require it before acquisition or before any licensing. Errors and omissions carriers also conduct their clearance review, which is another reason why preparation is extremely important before you ever reach an investor's desk. Your insurance company is going to ask very much so the same questions. So at the end of the day, you want to make sure you have as full of a protection as when you're about to create an audiovisual production actually worth distributing. So it's a pretty standard part of the process that shouldn't ever be underestimated. Moving on to a bit more fun topic, personally to myself, we do a lot of transactions in this space. We're currently in the process of negotiating a number of substantially sized acquisition scenarios and catalog of audiovisual works being acquired, as well as different mergers and acquisitions, and your run-of-the-mill financing of movies as well. Film financing structures, often seem pretty complicated, and they, sometimes are more complicated than people expect. They may involve equity investors, gap financing, collateral, tax credits, pre-sales. There's a lot of different mechanisms, right? An investor documentation must definitely comply with security laws, first and foremost, whether it be state blue sky laws or federal laws. All of that includes, any purchases of LLC interests, any purchases of revenue shares, waterfall structures, profit participation schedules. The waterfalls are especially important. They determine who gets paid first, how recoupment works, and how profits are distributed. Pretty much a badly drafted waterfall is one of the biggest causes of disputes in film and TV. So logically, you want to ensure yours are clear. Defamation is something that we have a lot of our clients reach out to us about, just due to the fact that I think people's nature is always to complain oftentimes, and living in a litigious country that we live in the United States, you always face a risk of ruffling somebody's feathers, and not necessarily always there is such a case to be made. However, we often deal with folks trying to claim defamation and protect our clients against it. Every production should go through a pretty extensive legal clearance review process. That includes reviewing scripts, depictions of any real people, trademarks, artwork, any archival footage, social media content, and content generated by users. Defamation and general privacy risks are pretty substantial issues, because just because a character is inspired by the real person doesn't necessarily eliminate liability. If you're filming a documentary, that creates additional considerations involving fair use and archival licensing, factual verification, which together with AI and deepfake related risks create a whole nother can of worms. But as productions increasingly use those AI tools, producers, definitely we recommend producers to evaluate the likeness rights, the consent rights, and any other clearances that play into any concerns of individuals for their likeness or image or appearance being used without their permission, or there being any inferences to them that they find offensive. You always need to kind of walk the thin line and ensure that you get all the necessary disclosures or consents and releases from relevant people participating, or brands or content that you include in your production. This slide is one of my favorite ones, is because it allows us to share a little bit of the values that Filmustage brings to the table, and as we establish our relationship, it's very promising to see the functionality that their set of tools and their software allows their clients to do, making our jobs much easier. One of the best ways to improve kind of legal efficiency is to identify the risks before I come into play at all, before legal review is ever in process. To give you a couple of examples from this slide, right? You can use the tool to do scene-by-scene reviews, to identify trademarks, identify any potential copyright material, review any permit requirements, flag any errors and omissions concerns. At the end of the day, the goal is never to turn producers or filmmakers or creatives into lawyers, but it is important in the same way how it is important for you to engage in education, such as this particular webinar or any others that you use in order to deepen your understanding of the business and legal processes involved. But I think it's very beneficial that we live in the age where tools like this exist that can help a production proactively track the legal issues and make sure that it's much easier and cheaper to insure, finance, and distribute your project. I think we've gotten ourselves to the end of the yellow brick road, more or less, and I appreciate everybody continuing to be with us. I wanted to give you a little bit of a final checklist in order for you to follow based on everything that we've discussed during this presentation. And the expectation is never for you to know everything. That's exactly why you need a team. That's exactly why you need accountants to deal with taxes, and lawyers to deal with contracts, and insurance companies to deal with what they do. But at the end of the day, a producer should have an understanding, at least of a surface level, of these requirements, because the ball stops with them, proverbially speaking, and at the end of the day, it's on them to ensure that the project gets filmed and packaged up, distributed, monetized to the utmost degree. And none of that is possible unless your legal entity exists, your chain of title is clean, your contracts are signed, your payroll works, your permits are secured, your insurance is bound, your financing is documented, and the waterfall structures are finalized. I would say these are some of those main ones, and obviously the tax incentives and distributor diligence being ready. All of that kind of wraps it up with ensuring that you have ownership, legal entities, crew agreements, talent agreements, as well as any and all financing, insurance, and permits documentation. Distributors, and any financiers, investors would always expect structured, organized documentation packages. I cannot underestimate how many times my firm was hired specifically to provide that function, just to structure data in a way to make it more processable and easier to understand, and more structured for the investors. Because at the end of the day, the cleaner the production infrastructure, the easier my job is, and the easier your negotiation is, the easier it is for them to say yes to you at the end of the day. With all of that, I appreciate everybody tuning in. I think the key takeaway from today is pretty simple. Legal planning is not separate from production strategy. It's part of it. You need to have a budget that is protected by legal strategy pretty much. Your timeline is dependent on your legal strategy. Your ability to raise funds and be financed is determined by your legal strategy. And your evaluation or acquisition price or distribution fee is at the end of the day based not just in your legal paperwork, but it will not be possible without it. So at the end of the day, preventing those issues from arising and doing legal work early is almost always cheaper than doing it reactively. And strong chain of title and clear production documentation will create that long-term value for your project. Thank you kindly. Appreciate everybody tuning in today. I hope you're able to pick up a thing or two that's going to come in handy in your movie making career. Feel free to use the contact information on the slide for any follow-up questions that you have, or if in case you wanted to reach out and schedule a consultation. The attorneys at my firm do not charge for introductory consultations. We like to share our opinions and share our recommendations with clients and give them an ability to assess our general value before we ever put any invoices in front of them. So feel free to reach out. We like to keep our doors open. And I wanted to thank the folks at Filmustage again for giving me the opportunity to speak to you today. And I hope that a lot of people who see today's presentation are going to come off with some value and some productive, practical recommendations that they can implement in their own movie. Thank you so much. Appreciate everybody.